Hello and welcome to the next of our full course lectures. We're still continuing our look at corporate governance. We're looking at each area in detail and we're going to look here at the directors and committees. We talked in detail about the board last time and the board structure. We're now going to look at the actual members on the board and then some of the committees that are offshoots of that board. So we're going to think about the directors first of all, and particularly induction processes for directors. So when a new director is appointed to the firm, they'll need an induction, they'll need an introduction to make sure that they know what their job and what their role is on that board. So it's an induction for directors. Now it's primarily for non-executive directors because these directors, remember, don't work day to day within the business, but it will relate to executive directors also. So if you get an illustration on this in the exam, what you'll need to do is you'll need to think to yourself, number one, is the director a non-executive director or an executive director? Because non-executive directors will need information in their induction, of course, but they won't need the level of information that executive directors will need. Executive directors will be working day to day in the business and will need detailed information on how to go about carrying out their job, on how to run the role that they have been given. So really an induction is to gain understanding for the directors. It's so that they can understand the business, so that they can understand the markets that that business is involved in, and so that they can perform their role comprehensively. So, the process for the induction. Well, the induction must be comprehensive. It must cover everything that those directors need to know. So for non-executive directors, it'll be the structure of the organisation, the strategic direction of the organisation, the markets in which that organisation is involved, and the key players within that market. They'll then need to understand what their role is within the board. So this needs to be tailored towards the directors. If, for example, it was an executive director, it would need to be much more detailed and comprehensive than we just discussed for the non-executive directors. It would need to go into the actual detail of the job that they're expected to do, the day-to-day procedures, their reporting lines, the management structure. That's the sort of information that they will need in order to carry out their job effectively. So it might involve written information, so it might be a pack that's given to the directors, or it may be a presentation perhaps by other directors or senior members within the organisation. However, whilst it needs to be comprehensive and give them everything they need to know, it can't be too detailed, particularly for non-executive directors. We don't want to overburden them with too much information and they never really get to grips with that role. So we need to get the level of information that's enough to be comprehensive, but not so detailed that they really can't understand what their role is. So what will the induction involve? Well, it will outline various things. It'll outline, first of all, the director's duties. So that might also involve their relationships within the firm. So what other directors they have there, how they will report to directors, and how they will be forming those relationships with other directors. So it'll set out their duties so they're clear at exactly what they're there to do. It'll also set out the company's strategies. Now that will go into the values of the company, it'll go into the culture of the company, it'll go into the strategic direction of the organisation, how they've got competitive advantage and how they seek to maintain that competitive advantage. It'll also set out the board operations. They'll need to know that. They'll need to know how the board is structured, they'll need to know how the board works, and they'll need to know what their role is in that board. Particularly if they are executive directors, they'll need to know what procedures there are that relate directly to them. As I mentioned, they'll need to know their reporting lines, who they report to, who reports to them, the structure of the organisation, and the policies and procedures that will directly impact on their job. So let's look at this in a little bit more detail in illustration 1. So again, read through the scenario, see if you can come up with some ideas, and then we're going to learn from the answer and see what we come up with. In illustration 1, the requirement is to explain the content of a director's induction programme and assess the advantages of such a programme for SAN. So we've just been talking about the induction of directors into the organisation. We're going to use that knowledge and we're going to look at some other ways that we can think about it, and we're going to look at how that would be applicable to Sam in this illustration, who's a new finance director. He's from another country, he's from another culture, so he really needs an induction into the organisation. First of all, Director's Induction Programme. Remember, the overall purpose of the induction is to minimise the amount of time for the new directors to become effective in his or her new job. There's several aspects to this director's induction, as we've already discussed. So it's going to convey to the new starter the organisation's norms, values and culture. So we said that in the session. So looking at this scenario, it's especially important when the new employee is from a different type of culture. Because Sam moved from a different culture to join this company, he's had to adjust to a new national culture as well as a new corporate culture, and we can see that he may have some misunderstandings from the detail in the scenario. So we can see that he's misunderstood some of the cultural norms, because it's been alleged that he made what he considered normal, but what was perceived as an inappropriate remark to a young female employee. This perhaps could have been avoided by an induction process to get him into the understanding of how the company operated and what the cultural norms were within that company. So to communicate also practical procedural duties to the new director is a big advantage of an induction programme. So that will include company policies, especially those relevant to the new employee. And in Sam's case, this would have involved his orientation within his place in the structure, his reporting lines and other practical matters, just to give him an idea of exactly what it is that he's going to be doing. Remember, Sam's not a non-executive director, he's an executive director. He's going to work every day within the organisation, so he needs to understand how to go about undertaking his role. So in the scenario, we can see that he made a simple error in positioning his office furniture incorrectly. So again, this is entirely avoidable. The induction programme could have provided him with the appropriate content on company policy in this area. He simply wasn't aware of it. So that's a good example of how the induction programme could have helped Sam to understand what the policies were in this relatively simple situation. So also the induction process will convey an understanding of the nature of the company, the operations, strategy, key stakeholder, external relationships, all of those the directors will need to understand. So an induction process is the easiest way to give them that knowledge. So for a new director, early understanding of strategy is essential, and a sound knowledge of how the company works will also ensure that he or she adapts more quickly into their new role. And we need to get them up to speed and get them working quickly, especially in a fast moving environment, which this appears to be given the information in the scenario. Also, if Sam's involved in reporting, the auditor relationship will be important, so he'll need to have that contact. And if he's involved in financing, the banks and other capital providers will also be important, or particularly more important. So we need to give him the details so he can contact them, so that he knows who the contact is in those particular organisations. So we can also establish and develop the new director's relationship through an induction programme. So that relationship with colleagues, especially those with whom he or she will interact on a regular basis. In this scenario, the importance of building good relationships early on is evident, because early misunderstandings can be costly in terms of the time needed to repair the relationships. And we see that Sam has had some misunderstanding with the alleged inappropriate remarks that he didn't even realise were inappropriate. An induction perhaps could have avoided that altogether. So that's just a little bit more detail on an induction and how you could apply it to a scenario. So we should now understand exactly what the induction process is for new directors coming into the business. Once they've been inducted into the business, they'll also need ongoing development. So it's not just a case of we conduct their initial induction. It's a case of we actually bring them into the business and we develop those directors by ensuring that they are informed fully. So the further information that they'll be given on an ongoing basis will be, first of all, the company history. So they'll need to understand what that company's done in the past in order to maybe advise on how they should proceed into the future. That will also give them an insight into what has worked in the past, what maybe hasn't worked in the past, and how they can use that to develop the business on an ongoing basis. So they'll need to know the company history. They'll also need to know who the company advisors are, so that will be for informational purposes. So if they ever need to contact the legal team, they'll need to know who that is. They'll also need to know the major shareholders. We'll see as we go through the rest of the module that institutional investors, for example, are very, very important to a lot of companies. So we'll need to know who those major shareholders are. Perhaps it's one individual, perhaps it's a major pension company or insurance company. Who are those major shareholders? How are they going to manage the relationship with those shareholders? And of course they'll need the financial statements, so they'll need to be given the accounts on a timely basis so that they can assess them, so that they can understand them, and so that they can get to know them. So all of that information will be given to the directors on an ongoing basis. They'll also get continual professional development. Now that's to ensure that we have directors that are bringing something to the business, that are adding to the knowledge and experience in that business. So what this will do is it'll refresh the knowledge and skills that those directors bring. So continual professional development means that we're training the directors on an ongoing basis. We're keeping them up to date with new developments. We're keeping them up to date with industry developments and with their own professional developments. That will mean that we develop a board that has those skills and knowledge that we require. So we don't just expect them to get it themselves. We're going to develop those directors to ensure that they have those skills. We'll also communicate changes to them. So particularly when it comes to financial accounting, they need to be aware of the different changes that come through different regulations. And particularly if they're in a highly regulated industry, they'll need to be aware of changes as and when they occur. How do we do that? Well, we professionally develop those directors. All in all, continuing professional development is a way that we support directors. Okay, we use the directors to manage the business and to push the business forward, but we need to provide them with the support so that they have the knowledge and the skills to bring value to that business and to do their job effectively. So we have ongoing development for those directors. Some of the legal aspects that directors will need to be aware of. Number one, the board is bound by law. So there are legal requirements when it comes to the board, and those requirements will be specific to the jurisdiction that the company operates in. So the directors are bound by the legislation in that jurisdiction. They're also bound by the duties that are set out for those directors. So they'll have both the legal requirements and they'll have duties that are set out perhaps in the Articles of Association or perhaps by regulatory authorities in the jurisdiction in which they are actually located. So some of these will be, number one, the Articles of Association of the business. So there may be specific duties set out for the directors of that particular business in the articles of that company. So if there are, well then the director is going to be bound by those duties. There may also be shareholder resolutions passed. Again, these would bind the directors and these would make sure that the directors have to actually carry out those duties. Or there could be legal provisions. As we've said, there may be legislation that applies to directors and means that they have to conduct themselves in a certain way. Also, there'll be decisions made by the board that will be binding upon the directors. So once those decisions are made, the majority on the board approves them, well then that means that that is what is going to happen and the directors are bound by that decision. Remember, this is another example of a fiduciary relationship. So what we have here is a duty of care from the directors to the shareholders, and they have to act in good faith. So remember that duty of care. The directors owe a duty of care to the shareholders because they're managing their assets. So the directors need to understand those legal aspects. If they don't, how do we go about removing a director? So removal of directors. Well, there's various ways that directors can be removed. First of all, and the most common, is retirement by rotation. So this is not removing them at a particular time, but In a rotational way, the directors actually retire. So the longest serving director retires at the AGM. Now usually this rotation will happen at least every 3 years. So at the end of each 3-year period, we have a director retiring. So that means that 3 years pass, the longest serving director retires. The next year, another director who served for 3 years retires. The next year, another director who served for 3 years retires. And in that way, we're rotating the board. Now, those directors may retire and then be appointed again, so they may conduct themselves in the way that they retire, but they put themselves up then for re-election, and then the shareholders can decide to re-elect them if they want to. But that's not always the case. They may just retire and then new directors come in to be replacing them. So what does that actually mean? Well, it means that we don't have any vacuum created. Now what do I mean by that? I mean that we don't have a case where maybe after 5 years, 3 directors all retire at once. So there's no vacuum created because every year we've got directors retiring and being replaced. So we don't get a case where a lot of directors are retiring all at the one time and a vacuum of power is created. That can be particularly damaging for a business, especially one that's in a fast-moving industry where new directors need to come in and try to understand that industry to actually provide value. So no vacuum is created using this director's rotation. We also get that vote of confidence in the directors. So if the directors retire and ask to be appointed again, well then the shareholders can choose whether to vote them in again or not. If they're voted in again, well that's a vote of confidence. So they say, well yes, we want you back, although you've retired, we're going to bring you back in again for another 3-year period. So you can get that vote of confidence. On the other side of that, we get an orderly replacement. If the shareholders aren't happy with the director's performance, well, they know that they're going to retire in the near future anyway. If they don't feel that they've done a good job, well, then the shareholders don't need to vote them back in again. So we get an orderly replacement of the directors in that way. So retirement by rotation is the most common way that directors will be replaced. There may also be termination of a director's contract. Now that could happen for various reasons. It could be simply through death, the director dies and that is the contract terminated. It could be through resignation. So the director chooses to resign, the shareholders accept that resignation and they don't seek re-election. It could be that they retire by rotation and don't seek to be re-elected, so the shareholders don't get the chance to vote them back in again. It could be that they were bankrupt. Remember, if you're bankrupt, you're not able to act as a director for a certain period of time, the period of your bankruptcy. Or it could be through disciplinary procedures or absence. We already mentioned this in one of the previous lectures, that the directors must attend the directors' meetings, the board meetings. If they don't attend the board meetings over a period of time, well then they can be terminated. They can be removed from their directorship. So those are some of the particular ways that a director's contract could be terminated. What about disqualification? How could we actually, or what sort of things would disqualify a director from performing their duties? Why would they have to leave their post? Well, wrongful trading would be an example of a reason for disqualification of a director. That means that a business is trading when insolvent. A limited company cannot trade when insolvent. If that was found to be the case, if the business was trading when insolvent, the directors are responsible for that. And they would be disqualified from being a director for a period of time as a result of that. So wrongful trading, a business trading when insolvent, would be grounds for disqualification. Failure to prepare accounts, so if the accounts weren't prepared and submitted, then that could ultimately lead to disqualification of that director. Likely for not keeping records. So the same as not preparing accounts, if you don't keep detailed records as a director, particularly if that business then becomes insolvent or is liquidated, well then that is grounds for disqualification of that director. Also, failure to pay tax or to file returns will also be grounds for disqualification ultimately. So all of those are reasons that a director may be disqualified from their position. Let's look in particular at this retirement by rotation that we discussed in illustration 2. Again, look through the scenario, use what we've talked about here, and maybe have a go at answering the question, and then work through the answer with me. In illustration 2, the requirement is to define retirement by rotation and explain its importance in the context of Roche and Company. So we've already discussed retirement by rotation. Let's talk about it here and see if we can come up with a definition. So retirement by rotation is an arrangement in a director's contract that specifies his or her contract to be limited to a specific period. So that's typically going to be 3 years, as we said in the lecture. So after those 3 years, he or she must retire from the board or offer themselves up for re-election. So you either retire and that's it, or you retire and you offer yourself up for re-election by the shareholders. So the director must be actively re-elected back onto the board to serve another term. So they can't just serve another term, they need to be re-elected by the shareholders. And the default is that the director retires unless they're re-elected. So retirement by rotation reduces the cost of contract termination, particularly for underperforming directors. They can simply not be re-elected after their term of office expires, and they'll be required to leave the service of the board as a retiree. And of course that will depend on their contract terms, but remember that means that we don't have to sack them. We know that they're going to be retiring within the short term in any case. It also encourages directors' performance, so they know they're going to be assessed by the shareholders and reconsidered after 3 years, and that will focus their minds upon the importance of meeting the objectives in line with the shareholders' aims. So it'll focus them in on that performance. They know they need to try to get re-elected in 3 years' time. So it's an opportunity over time to replace board membership whilst maintaining a medium-term stability of membership. So that means you're losing maybe 1 or 2 board members at a time. So when it comes to Roche, rotation by the directors would enable the board to be changed over a period of time. We can see that there's evidence that some of the directors have stayed longer than is ideal, and that's maybe because of those links with other board members that go back many years. So it seems like it's becoming a little bit stagnated. So that retirement by rotation would enable them to get that board moving, to get new directors in, and maybe give the company a new focus. Moving on then to some other aspects that we need to understand when it comes to directors. First of all, employment of the directors. They will be given a service contract. That service contract is the legal terms of their service. So the things that will be contained in this, well, it's really an employment contract. So this will be important dates. So when they're going to start, what their notice period would be, for example. Also what the duties they would have would be, the remuneration that they would be entitled to, the employment details of what they're expected to do, and of course the termination procedures. So the director's service contract is very like an employment contract, similar to what you may have received yourself. Also, there may be conflicts or disclosures required. First of all, conflicts. Well, there'll be a contract with the company that covers any conflicts, particularly conflicts of interest. Large property transactions would be a conflict of interest, or indeed loans with the company. So any of these would constitute a conflict of interest, and these would need to be disclosed. So indeed, any other contracts that director had with the company, that would be a related party contract and would need to be disclosed. Large property contracts, as we've said, would need to be disclosed, and loans, all of that would be disclosed by the directors and would be disclosed in the annual report. Remember, insider dealing. Insider dealing is the use of information for personal gain. So for example, let's say the director knows that the company isn't doing very well, but that hasn't been disclosed yet in the annual report. Well, they wouldn't be allowed to short sell the shares, for example, to make a gain. That would be illegal. And in fact, the director could well go to jail for doing that. Even if someone acts on behalf of that director, perhaps maybe buying the company shares when he expects them to do well based on some insider information, like a merger or a takeover, again, that is illegal and the director could go to jail for that. When it comes to performance of the directors, this is of crucial importance because remember, directors' remuneration must be set on a basis that involves a performance measure. So the director's remuneration that they get will be based on their performance. So in order to do that, we need to assess their performance. So the board and the members of the board will be assessed on their performance once a year. So when it comes to the board in general, what could we look at to try and assess their performance? Well, we could see, did they achieve the targets that were set for them? So at the start of the year, targets will have been set, key performance indicators. Did they achieve those targets? Did they achieve the strategic success that they expected? So again, they'll have set a strategic direction. Are they achieving that strategic direction? Are they achieving the competitive advantage that they expected to? Risk management is a big area that the board is responsible for, as we'll see in detail later on in this module. So have there been any risks that were overlooked? Was their risk management accurate? Was that risk management suitable? Crisis management, has there been problems in the year? How were those problems dealt with? How did those directors and the board actually manage the crisis as it arose? So all of those areas could be assessed to see how the board has performed over the year. When it comes to the non-executive directors, how can we assess their performance? Well, if we were looking at the chairman, we could look at their leadership of the board. We know now what the role of the chairman is. We know how they should be the leader of the board. They should be the face of the board, and they should manage that relationship with shareholders. So we could also look at communication, particularly with the shareholders, but also with other stakeholders. How was that done? Was it done in an accurate way? Was all of the information communicated? Were the disclosures that were required to be done? What about contribution to meetings for non-executive directors? Remember, we want these non-executive directors to provide us with expertise. So are they contributing in the directors' meetings? Are they coming up with ideas? Are they critically assessing other ideas and giving the benefit of their knowledge? So have they got that effective probing of other ideas? Are they looking and criticising and thinking about how those ideas could actually work? Remember, we talked about CPD. Well, are they doing that? Are they refreshing their knowledge? Are they attending the CPD events that have been put on by the company for those directors? And do they have the understanding both of the company and of the issues that are facing that company in order to provide value to the company? So all of those are ways that we could assess the performance, not just of the board, but of the non-executive directors. We can then set their remuneration based on that performance, and we'll look in detail in the next lecture at a remuneration for directors. The last thing I want to look at in this little session is nomination. So nomination of directors should be done by an independent committee. So that will be the nomination committee. That independent committee should have a majority of non-executive directors. So it doesn't have to be all non-executive directors like the audit committee, for example, would be all non-executive directors. But that independent nomination committee should have a majority of non-executive directors on it. It should also have formal, transparent procedures. So there should be formal procedures set out, and those procedures should be transparent. Remember, we discussed transparency in a previous lecture, i.e. we need to disclose how it actually works. Now, what's this nomination committee responsible for? Well, we know it's responsible for nominating directors, but what else will it be responsible for? Well, it'll be responsible for reviewing the board composition. So they'll look at the board and they'll see how it's structured. They'll see, is there a half and half structure in terms of executive and non-executive directors? Do we have a good diversification on the board? They'll look at that and see, do we need to change the composition on the board? So they'll ensure that diversification that's now required when it comes to the board. They'll also undertake succession planning, so they'll not just think about nomination once someone has retired or resigned or had their contract terminated. They will think about succession planning. They will have a plan for when directors are removed or retire. They will then recommend candidates based on the criteria that they will set for those candidates. So let's look at this in a little bit more detail in illustration 3. Again, look at the scenario, understand it, maybe have a go at the question, and then we're going to learn a little bit more by going through the answer. The requirement in illustration 3 is to explain the roles of a nominations committee and assess the potential usefulness of a nominations committee to the board of Roche and Company. So we're using the scenario from the previous illustration and we're thinking about the nominations committee here. So the nominations committee, remember, advises on the balance between executives and independent non-executive directors. So that's the balance of the board structure. It also establishes the appropriate number and type of non-executive directors on the board. And remember, the nominations committee is usually made up of non-executive directors. That might be all non-executive directors, but it will definitely be a majority of non-executive directors. So the board structure is the thing that the nominations committee is particularly interested in. So it'll establish the skills, knowledge and experience both possessed by the current board and will note any gaps that will need to be filled. So it'll act to meet the needs for continuity and succession planning, especially amongst the most senior members of the board. So we'll think about how we're going to replace those members should they retire, perhaps by rotation. So the nominations committee will also establish the desirable and optimal size and diversity of the board. Remember, we need a diversity to represent on that board, bearing in mind the current size and complexity of the existing and planned activities and strategies. So the board needs to be suitable to actually push those activities and strategies forward. When it comes to Roche, there are a few things that the nomination committee could help with. First of all, it could recommend how many directors would be needed to run the business and plan for recruitment accordingly. So they could actually explain how many are required. We can see that there aren't enough non-executive directors on the board, so by having a nominations committee they could identify that and then rectify it. Also, we have a problem here with independence. The closeness that the non-executive directors have to existing executive board members potentially undermines their independence. So we can see that from the scenario. And a nominations committee could help to rectify that. It could identify that that is a problem. Lastly, the nominations committee could make recommendations for the succession of the chairmanship. We see at the minute family members usually take up this role, but that might not be in the interests of Roche. So maybe family members shouldn't always occupy the senior positions, and the nominations committee could see whether that could be changed. So that was our session looking at the directors and committees. So we're still moving through corporate governance here. In the next lecture, we're going to continue to do that.